Hello, welcome to the channel. My name is Vitaly Kurchin, top firearm rights lawyer in Washington State. Today, I'm going to talk about out-of-state criminal history and how it affects your firearm rights in Washington State. Stay tuned. Washington State has a lot of things going for it. Between pristine nature, natural wildlife, picturesque mountains, shining seas, and a strong economy, Washington State is a magnet for transplants from across the country, whether it be for work, play, or as part of the armed forces. However, Washington State is not a great climate for the Second Amendment, and it has three very unique features that many states don't. These features can really be a landmine for the unwary, so it's important to educate yourself early. The first is comparability of crimes. If you have criminal history in another state, Washington state law requires that your convictions in the other state must be compared to crimes in Washington state to determine if the out-of-state conviction is comparable to a felony under Washington state law. This is a confusing concept, so let me explain with an example. Let's say that you were convicted in California of misdemeanor theft and the value of the theft was $850. This crime, even though it's a misdemeanor in California, would be comparable to a felony in Washington because of the value. The value cutoff for felony classification in Washington is $750. Because the value of the theft in California is over $750, the misdemeanor crime there is comparable to a felony crime here. Explained in a different way, if you had committed the same crime in Washington instead of California, you would have been convicted of a felony instead of a misdemeanor. I mentioned California in this example because California has a unique feature of its own in that it has what are called wobbler offenses. A wobbler offense allows the prosecutor to charge the same crime with either a felony or a misdemeanor classification. Additionally, California has what's called a Penal Code 17B reduction from a felony to a misdemeanor. While securing such a reduction may restore your firearm rights in California, it does not necessarily restore your firearm rights in Washington State. Although I have used California in the example, this issue is by no means limited to transplants from California and may arise regardless in which state the conviction occurred. If your conviction is in the other state is comparable to a felony in Washington state, then you are prohibited from possessing a firearm in Washington state until you have your firearm rights restored. The fact that you are allowed to possess a firearm in the other state is irrelevant. The question of whether a crime from another state is comparable to a felony in Washington is extremely complex and requires evaluation by an expert. Do not rely on Washington State Patrol to have made an accurate determination regarding comparability. The second feature is how Washington state law treats deferred or withheld adjudications. A deferred or withheld adjudication is a type of disposition that many states utilize that essentially allows a person to plead guilty but not receive any jail or prison time, instead opting for certain probationary conditions. Washington state law disregards any sort of deferred or withheld disposition. Washington state law defines a conviction as the plea of guilty. What happens with sentencing is not relevant. This stands in contrast to how most states treat deferred or withheld dispositions. In most states, once the conditions of the deferred or withheld adjudication are completed, the case no longer counts as a conviction. This includes for firearm rights purposes, which means that you may have been allowed to continue possessing and purchasing firearms after your case was over. But not so in Washington state. Since the deferred or withheld disposition required a finding of guilt, that is all that matters under Washington state law, and that case continues to count as a conviction here. If you have a deferred or withheld adjudication in another state, For a crime that is comparable to a felony in Washington state, you are prohibited from possessing a firearm here until you have your firearm rights restored. Finally, if you have criminal history in another state, you may be prohibited in Washington state even if you've received a governor's pardon in the other state. Washington state law will only recognize a pardon as nullifying the firearm prohibition if that pardon was based on a finding of rehabilitation or innocence. A general pardon is not sufficient. So even if you received a pardon in the other state, unless that pardon was based on a finding of rehabilitation or innocence, that pardon would not be recognized by Washington state law, and you would remain prohibited from possessing a firearm until you have your firearm rights restored. If you've moved here and you have criminal history in another state, you may need your firearm rights restored, or at least your case history from the other state evaluated to determine if you are prohibited in Washington state. We deal with this situation all the time, so do not hesitate to reach out for a case evaluation. We can assess your needs and provide you with options on how to proceed. Thanks for watching, and I'll see you next time.